The Seventh Amendment to the Constitution guarantees the right to a jury trial. However, for tens of millions of Americans, this constitutional right is an empty promise. Instead of having their day in court, people are forced into arbitration by the fine print buried deep in employment contracts, product manuals, and terms of service. I'd like to turn to a brief video featuring 3 individuals who were denied their day in court as a result of forced arbitration clauses that they didn't know very little, if anything, about. Please proceed.
So what is forced arbitration?
Basically, it means you're giving up your right to take a dispute to court. This is a constitutional right you have, and you're giving it up even before you know that there's a dispute.
Arbitration clauses are typically buried in the fine print of a product manual or websites. Most people don't even realize they are agreeing to them.
The used car John Purz bought 7 years ago has hardly ever left the garage. There was an engine problem the dealer first failed and then refused to fix. Then Purz found to his dismay he'd agreed to binding arbitration and couldn't sue.
I didn't even know what an arbitration agreement was. I was really beside myself that we've lost our right to court.
I'm a lieutenant commander in the Navy Reserves and a federal employee who was fired on the eve of my deployment to Afghanistan and later forced to arbitrate my discrimination claim when I returned home. In November 2012, I received orders to deploy to Afghanistan for 12 months. On my last day of work, my colleagues greeted me with a standing ovation. At noon, BLB held a surprise party in my honor. Around 4:45 that same afternoon, I was called into a meeting in the HR department where I was fired and told my position would not be available to me after my deployment.
My name is Jasmine Wilson, and I am a former Tesla employee. If I didn't sign the arbitration, then there was no opportunity for me to maintain or continue with the job. I was catcalled, I had racial slurs shouted at me. I had to give myself a pep talk every single day to go to work. I dreaded it, yet I needed my paycheck. I was often blamed for the harassment I received. I was retaliated against. They used the weapon of forced arbitration to avoid public accountability.
Forced arbitration is pervasive. It affects more than 60 million workers. An estimated 825 million consumer arbitration agreements were in force in 2018, a number that undoubtedly has gone up since then. If you've activated a cell phone, signed up for a credit card, bought a mattress, television, countless products, you likely agreed to arbitrate any future disputes with the manufacturer or service provider. Don't be embarrassed if you're just learning that you likely waived your constitutional right to bring a claim in court. You're part of the 90% of American consumers who use popular products and had no idea they'd signed up for forced arbitration. All of us, quote, agree to forced arbitration when we click that button or check that box, accepting terms of service. We may have no idea we're agreeing to this process when we sign up. The rules governing arbitration often limit the information victims can get from corporations, making it even more difficult to prove their claims. The process is overseen by arbitrators who can be biased in favor of one side or the other, usually corporations, because they want to ensure a steady pipeline of future work. Those arbitrators aren't bound by precedent, and their decisions are only subject to limited judicial review. The problems are compounded by the secretive nature of this process. Nowhere was this troubling combination more pronounced than in cases of sexual assault and sexual harassment. For years, predators like Roger Ailes preyed upon women without fear because they or their employers would hide behind confidential arbitration proceedings to sweep abuse under the rug. Thankfully, that's no longer the case. Brave survivors like Gretchen Carlson with us today, thank you for joining us, step forward to break this cycle of abuse. As a result of her unrelenting advocacy and this committee's determination to do something on a bipartisan basis, the Ending Forced Arbitration of Sexual Assault and Sexual Harassment was signed into law by President Biden in March of 2022. As the name suggests, this law prohibits forced arbitration in cases of sexual assault or sexual harassment. While this marked a significant achievement, there's more to be done. We'll hear from witness Joanne Grace, how forced arbitration is used to cover up illegal age discrimination, an issue of great interest to the senator from South Carolina. The same is true of racial discrimination, abuse in nursing care, and countless other harms. Joanne and others like her deserve their day in court. That's what the Constitution promises. That's what the Congress should provide. I want to thank Ranking Member Graham and his staff for working with us on this bipartisan basis to select today's witnesses. And before I turn the microphone over to Senator Graham, I want to congratulate South Carolina and Iowa for their terrific basketball experience over the last 2 weeks. Senator Graham.